the Supreme Court and Appellate Advocacy programs at the Heritage Foundation.
Well, thank you very much for joining us today for the Heritage Foundation's annual Supreme Court preview for the court's upcoming 2025-2026 term. As you just heard, my name is Zach Smith, and I serve as a senior legal fellow and the manager of the Supreme Court and Appellate Advocacy program here at the Heritage Foundation. As we do each year at this time, court watchers are preparing for the justices to return to the bench and to begin hearing oral arguments for cases in the new term. The justices this year didn't receive as much of a summer break as usual, given the high number of requests on its emergency or its newly named interim docket, where the Trump administration has had very good success so far. On the merits, too, the justices are being asked this term to reconsider long-standing, though constitutionally dubious precedents involving the separation of powers, and the justices will also hear cases involving the president's power to impose tariffs. They'll hear important free speech and religious liberty cases, and one case involving redistricting will have impact on the upcoming midterms and many future elections as well. To help me discuss these topics and many more, I'm very pleased to be joined today by Professor Chad Squitieri and Mr. James Burnham. Please join me in welcoming them to the stage. Thank you. I'll give a very brief introduction of Chad and James, and then we'll dive right into our topics for discussion today. I'll start with James. James is the founder and managing partner of King Street Legal. He recently returned to King Street after serving as the general counsel for the Department of Government Efficiency, DOGE. In that role, he designed the legal structure of DOGE, advised DOGE personnel on policy initiatives across the executive branch, and supervised dozens of DOGE-related lawsuits against the executive branch, which had great success at the Supreme Court. Before founding King Street Legal, James was a litigation partner at Jones Day, a senior official in the Justice Department in the Civil Division and in the Office of the Attorney General, and he served as a senior associate counsel to the President. James also clerked for Justice Neil Gorsuch and for Judge Alex Kaczynski. He graduated from the University of Chicago Law School and earned his bachelor's degree at the University of Texas. To my immediate right is Professor Chad Squitieri. Professor Squitieri joined Catholic law after practicing law at Gibson, Dunn & Crutcher. Before that, he served as a special assistant to former U.S. Secretary of Labor Eugene Scalia and as a law clerk to then Chief Judge D. Brooks Smith of the U.S. Court of Appeals for the Third Circuit. Professor Squitieri's scholarship addresses administrative law and constitutional law issues. He serves as the director of the Separation of Powers Institute and as a managing director of the Center for the Constitution and the Catholic Intellectual Tradition. He was recently appointed to serve on the Administrative Conference of the United States, and Professor Squitieri graduated from UVA Law School and from Florida State with his bachelor's degree. So we'll dive right into our conversation. James, I'll turn to you first to talk a little bit about the emergency docket. And obviously, there's many issues floating around with the emergency docket. We've seen a big uptick in the number of cases filed on the emergency docket. What do you think is driving that, and what are some of the other things you're looking for on that docket?
I can't keep up with what we call it, the emergency docket, the interim docket. I would just call it the docket. But I thought, so maybe I could like signpost some stuff that we can talk about, and then I'll just kind of go through it. So I have a list. We're going to do Lisa Cook, really fun. Rebecca Slaughter, also fun. TPS, temporary protected status, less fun. USAID, which is a case that I personally lived from like the very beginning of the administration, very fun. And then finally, the administration's win rate and lower court defiance, because I think those are linked. But before we like dive into the Lisa Cook situation, I mean, I just want to talk a little about the docket. I mean, this is just the docket, right? I mean, everyone here is a lawyer, I imagine, or most of you are lawyers. You go to lower court, okay, you're not a lawyer, but you seek someone shook their head. So there's at least one non-lawyer. But it is very common to go to court and ask for emergency relief. This is a very typical thing. We call it a preliminary injunction or a temporary restraining order, and we can talk about the abuse of those when we get to lower court defiance. And if you lose or if you win, you can, actually only if you lose, you can go to the circuit court and you can ask them for emergency relief. And so the idea that there's some like weird reason why the Supreme Court cannot or should not grant emergency relief in a case that satisfies the standard And the standard is high, but it's not that high when we're talking about cases that involve the president. The standard is that they're likely to grant cert, and there's a good chance they'll reverse. Guys, I promise, you can go through every single emergency docket order, and that standard is amply satisfied. When a lower court judge somewhere shuts down an administration initiative, there's a very good chance the Supreme Court would ultimately grant cert. And given the nonsense that we've been dealing with for the last 6 months, in these cases, there's a very high, I would say overwhelming, likelihood that it would reverse. So the whole idea, this like shaming of the court, that this is some scandalous thing, and by the way, the lower courts are not engaging in like platonic reasoning in a lot of these emergency orders. Some of them were ex parte. So anyway, I really, really resist the idea that the court has some special obligation to explain itself when it exercises power it has. What's really going on is we have a Supreme Court that is more rule of law oriented than some of the circuit courts and certainly a lot of the district courts, and people are trying to bully them out of using the power that they have, that the Constitution gives them to supervise the courts that exercise purely derivative power. Sorry that wasn't on the agenda, but I thought it was important to say. Lisa Cook. Okay, so I love the Lisa Cook case because it's just like a great, it's actually like, the administration has handled this extremely well, and I'm just very proud of my friends. I had nothing to do with it. I wish I had. I am proud of the people who figured all this out. So the first point is, for those who don't know, Lisa Cook is a governor on the Federal Reserve Board, okay? So the Federal Reserve Board, like many places, has for-cause removal protections. I don't know, but I suspect that that is one set of for-cause removal protections. There are 5 justices that think they are probably okay. They basically said this in one of the interim orders. I think it was Slaughter. I forget which one.
Wilcox.
But which one?
Wilcox.
Was it Wilcox? There's basically a random paragraph in the middle of the order that's like bad, 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 but you know, the Federal Reserve probably okay, apropos of nothing. Moving on to the next paragraph. So like, clearly the court is thinking that you can't just remove these people at will. They haven't said it yet. Maybe that'll be tested, maybe it won't. But this case also will not test it because the president did not say he's firing Governor Cook or whatever, I guess that's her title, for now, for no reason at all. He said he's firing her because she committed mortgage fraud. And by the way, it looks like she did commit mortgage fraud. You're not allowed, I only have one house. I mean, I'm sure this is the Heritage Foundation. I'm sure some of you have multiple houses. It's a nice place. I only have one house. But it turns out that when you buy a house, you have to say whether it's your primary residence. Now, I am not a scholar of the English language, but even I could tell you that primary means the one you live in all the time, not the other one. And Ms. Cook appears to have said that they were both primary residences. Now, that seems like a bad mistake. You know, we're just lawyers, except for the guy who's not a lawyer. She's a Federal Reserve governor. Like, you would expect that someone on the Federal Reserve would be able to competently complete a mortgage application. So I just think it's like it's a great case because, you know, just like Caesar's wife must be above reproach, same for a Federal Reserve governor. They got this guy Pulte at the FHFA who figured out that this woman had filed the incorrect things. That's illegal if she did it on purpose. It's a crime if she did it on purpose. And I can't imagine that anyone thinks that's not a sufficient basis to remove her from office. The lower court, by the way, the main rationale the district court relied on is that it doesn't count because it happened before she was confirmed to the Senate, which is like insane. So you know, let's say we unearth footage that Lisa Cook had shot someone on Fifth Avenue, you know, the day before her Senate confirmation. Under the lower court's order, she's cool and can be on the Federal Reserve until her term expires, which is obviously ridiculous. The court's not going to say that. And then the only reason I think they haven't granted relief now, and then I'll stop in case you guys have something to say too, but is because they granted, and we'll get to Slaughter, but they have oral argument in Slaughter in December. Slaughter is about, she's an FTC commissioner. It's about whether they can be removed for cause, whether the for-cause removal protections are constitutional, and some other issues we'll talk about in a minute. With that argument coming, I don't think they wanted to rush an emergency order in Cook. It's also actually like a really hard order to write, right? So if you agree with everything I've said, and you think that they think the for-cause protections at the Fed do comport with Article 2, meaning they're permissible, they actually need to be pretty thoughtful about how they do this, because while it appears that the administration really does have Cook dead to rights, they're going to want to write this in a way that doesn't allow for, I suspect, for purely pretextual cause, right? And it's really tricky because I don't think you can have the district court review the president's factual basis. So I don't think you can say the rule is, oh, we're going to have basically a mortgage fraud trial in DDC to figure out what the president was thinking. I don't think the president's determination is reviewable. I would say it's not reviewable at all, but I suspect there are a few justices who will agree with the administration, but not go as far as I just did and say total unreviewability. They're going to have some sort of like basically backdoor, bad faith, whatever. And I think they just need to figure out how this works. And also, they lowered interest rates.
Yeah, the really only thing I would add to that is I think this decision was really well lawyered. I think the court is going to be kind of itching to give this kind of a quiet end. The president worked within the Supreme Court's telegraphed views on the Fed, that paragraph that James mentioned. I also lean toward this decision not being judicially reviewable. The statute simply says cause. Other statutes use things like malfeasance in office or what have you. This statute literally just says cause. There's no definition of that. That's an inherent political judgment for the relevant political actor, the president. There's no law there for a court of law to cling on to. So I agree with that aspect.
I will just say too, for those of you who want to serve in the government, get your mortgages fixed. The decision to turn the FHFA into this investigatory body is hilarious, but also something that will not go away. So I strongly recommend going and checking all your mortgages, making sure they're good to go, and so that the future Bill Pulte's of the world don't have anything on you.
Before we move to the Rebecca Slaughter case, James, I wanted to ask you about, and I guess maybe this is a segue into that case, one of the issues that seems to be lurking, and I think you posted about this a couple of weeks ago, is the remedial issue.
Oh, it's fascinating.
Even setting aside the other issues, what is the court actually entitled to do? Maybe you can talk a little bit about that for us.
Yeah, so remedies is not, people all want to take con law and talk about the theory and the separation of powers and Article 2. The remedy is actually so much more important on this one. So the reason, and I apologize if this is pedantic, the reason it's called Humphrey's executor is because William Humphrey was not alive. So the way the case happened was Roosevelt removed William Humphrey, who was a Republican holdover, who was not on board with the Roosevelt agenda. So he fires the guy. Then the guy passes away, and his estate filed a claim a suit in the Court of Claims for the back pay. And so they were not seeking he couldn't be reinstated. He was, had gone to another place. So there was, the ghost of William Humphrey was not trying to return to the FTC. And so the case is a very important substantive legal rule, right? Which is that the four cause protections, at least at that time, do comport with Article 2. But the remedy is one that I bet FDR was like, whatever, fine. The estate can have whatever, $10,000, inflation adjusted, maybe 100, and terrific. And so it doesn't actually stand for any of the things that we're seeing today. So the second question in the Slaughter case is whether a lower court has the equitable power to reinstall an executive branch official, or a pseudo-executive branch official if you accept her framing of the issue. There's a really good reason to think that that doesn't make any sense. Because if the district court has reinstated the executive branch or whatever, pseudo-executive branch person, then that person's boss is no longer the president. Their boss is the district court. So now you basically are putting part of the commission or part of the agency or whatever into judicial receivership, where everybody, now I'm sure plenty of judges would love this. This is basically what injunctions do anyway, is they just commandeer part of the executive branch. I don't love district court injunctions against the executive branch. But I think the court's going to say no, because I think they're going to say it is totally untenable if this officer wields some or all of the executive power, even aside from the merits. So even if the four cause protection were permissible in some context, although I think they're going to say those are not permissible, so maybe they won't reach it. But I think the answer has to be no, because it's just totally untenable, in my opinion, to have a district court in charge of, well, anything, but certainly the executive branch.
Sure.
Yeah, I think the remedial question is inherently tied up with the merits questions. If the president has the authority to remove Article 2 officials from office, which he does, I don't see how an Article 3 court has the authority to kind of trump that and reinstate the official.
Great. James, you want to move to temporary protected status?
Okay, yeah, sure. I told you this one's a little wonkier, but so temporary protected status is basically, it's in the immigration law, and it's basically an immigration waiver for an emergency. So the DHS secretary can give temporary amnesty to people that are fleeing like a war or whatever. And so the essence, the Haitian earthquake was a famous one. A lot of people from Haiti came here in 2010. We're actually litigating about the revocation of those people's TPS status today. It's 2025. The earthquake was 15 years ago. The statute says it's temporary and it's discretionary. So it's almost like You could think about it almost like as a pardon authority, right? It's basically a plenary authority the secretary has to say, oh my God, something horrible has happened in XYZ place. People from that place can come here for a temporary period while the bad thing is ongoing. While the earthquake is happening, the war is happening, the plague is ongoing. Well, maybe not the plague, because you probably don't want to, anyway. But anyway, you get the idea. So the whole point is that it's supposed to be short, temporary, and discretionary. Of course, that's not how anything works in our legal system. And so the administration has been trying to revoke TPS status for all these different groups of people that have had it for a very long time. And lower courts in California are, as you would expect, serially enjoining these revocations on a variety of grounds that are not lawful. In whatever it was, May, the case that went to the court is about the Venezuelans. I can't even remember why they got TPS status. It doesn't really matter. The administration said no more TPS, discretionary, remember? And the Supreme Court granted a stay in May with only one justice noting a dissent. That's Justice Ketanji Brown Jackson, God bless her. And so they issued the stay. The district court, and this gets into defiance, so I don't want to get too far down the road, but in a nutshell, if the Supreme Court stays the preliminary injunction, that means we're not supposed to have any more injunctions. Instead, God bless them, the district court went to a final judgment and issued a permanent injunction. And then the Ninth Circuit declined to stay the permanent injunction on the ground that maybe it's a different analysis. It is not a different analysis. It is the exact same analysis. And so we have a good example there of lower court defiance that we can talk about more soon.
Great. Chad, anything to add?
Not particularly. My understanding is the statute just says the president can afford temporary protected status for people with extraordinary and temporary conditions, and he's establishing as a factual matter those conditions are no longer present. So I don't think as a legal matter it's particularly interesting.
Great. Well, let's briefly do USAID, and then I would like to spend a little bit of time on the lower court defiance and win rate, if we could.
All right, so I'll do as briefly as I can. I mean, this was like my
Tall order.
Case. So USAID, everyone is very familiar, I assume, with what happened at USAID. That was a Doge operation. That was like at the beginning of the administration when Doge was at the height of its powers, and sort of Elon was still very close to the president. And so that was something that really consumed a lot of my time early on. And there was lots of litigation. There was a big case in front of Judge Ali. The very second, in fact, the administration lost. People don't remember this. The administration lost the first two stay applications they took to the court. The first was Hampton Dellinger, who was the special counsel that had been removed from office. They lost that on I believe on the appealability of TROs, which, I mean, how quaint that we were going to not review TROs. That is, I think basically just gone away in the time since, because the lower courts went totally ham on TROs after that. And then the second one was USAID, where we lost 5-4. Justice Alito wrote a very compelling, I thought, dissent. Justice Barrett had joined the others in denying relief. And so we lost. And they basically said we had to go back to Judge Ali. And the way it all shook out is we didn't have to keep all these grantees on the government payroll, but we had to make payments for the work that they had already done. Fine, okay. That's rough justice. It all kind of worked out. It happened. It's over. Except the district court said you also, the administration, cannot impound any funds that were appropriated to USAID. Okay, impoundment is the notion that the executive does not spend money at all that Congress has appropriated. It doesn't go to a particular grantee, you spend it at all. Now I'll get to the case and then I'll stop because we said briefly. So there's a statute called the Impoundment, sorry, it's like kind of complicated. There's the statute called the Impoundment Control Act that has this whole procedure for how the executive can propose to rescind particular funding to Congress. There's deadlines and all that. And Russ Vought and his brilliant general counsel, Mark Paoletta, have come up with this fantastic idea called pocket rescissions, where basically if you propose it at a certain time and Congress doesn't act, the rescission takes effect automatically. You can imagine that the USAID grant recipients, putative, are not thrilled with this maneuver, and so they sued about it and tried to get it enjoined. In a nutshell, the DC Circuit said you can't do that. This complicated statute does not allow private people to sue. It is Congress versus the president. That's it. That is totally right. And the Supreme Court, in an interim order, expressing only its preliminary view, provisionally agreed with that, issued a stay, and the money is now gone.
Very good brief overview.
Yeah, I did my best.
You did a great job. Let me ask you, piggyback on one quick thing before we go to lower court defiance, and maybe this will segue into it. What is the precedential value of these kind of intermediate orders that the court has been issuing?
I mean, it's the Supreme Court. I think they're obviously precedential. I mean, anything the Supreme Court does needs to be followed by the lower courts. The lower courts do not exist in the Constitution. The Supreme Court is the only court that the Constitution creates. For the lower courts, it says Congress can create them if it wants to. And so the idea that the Supreme Court, a formal order that it has issued, lacks precedential effect, I find absurd. I think it's crazy that the court even had to explain that. And then look, the precedential effect is, it depends on what has happened. So if they have ruled on a particular fact pattern, I think that you have to infer that the same fact pattern or analogous fact patterns come out the same way. Do you want me to talk about defiance? Because now we're getting into defiance.
Chad, anything you want to add before we go?
One point about the fiscal powers is, this case tees up kind of an annoyance I sometimes have when people talk about these types of issues. They refer to the power of the purse, but there's no that's fine to refer to that as for like a 7th grade Schoolhouse Rock type style. But if you look at the Constitution, there is no power of the purse. Congress has to rely on specifically enumerated powers to spend money. And they have to do that through the Article 1, Section 7 lawmaking process. And who else is involved in the Article 1, Section 7 lawmaking process? The President of the United States. And so you can bet that the President of the United States is going to be securing different amounts of discretionary spending authorities through different statutes. So all of these cases, I think you have to look at a very specific statute by statute basis. Here, the statute has this 45-day program that the president is taking advantage of. So I just don't think it does justice to think of the power of the purse in general. It has to be a statute by statute basis.
Great point. All right, let's do defiance. What do you have on that, James?
Well, so look, I mean, the administration wins almost all their stay applications. Okay, I think it's 84% win rate. We lost mine at the beginning. No hard feelings. It's fine. The Ali proceeding was horrible. It would have been a lot better if we had won that case, but it's all good. No hard feelings for me. Why are they winning so much? Okay, I think there's 2 reasons. One, the Solicitor General's office is actually really good and smart and has good judgment. And so, there are a lot of things that they could take to the court. They don't take everything to the court. They're at the court a lot, but the reason they're at the court a lot is because the lower courts, some of them, have completely lost their minds. And so I think the SG's office does a very good job of saying, okay, we're only going to take to the court things that we know we are going to win. That is what good lawyers do. They have the ability, because they have literally 100 of these things to pick, or maybe more, probably more than 100. God, the Doge litigation tracker, I think, was over 100. So they have the ability to pick the winners. So they pick the winners. And then, what do you know? The SG's office is pretty good at reading the Supreme Court and knowing what they're going to likely agree with. And so they win most of the time. They should win most of the time. What's the other thing we can infer from the high win rate? It's not this idea that the Supreme Court is like in the pocket of dictator Trump or whatever. It's that the lower courts have gone crazy. And the lower courts are enjoining things everywhere. And by the way, they're not even doing it after thinking about it. We had multiple cases when I was there where the lower courts are issuing ex parte TROs. Okay, an ex parte, that means that the government, the other side, doesn't even get to respond before injunctive relief is entered. That is a procedure for emergencies, like real emergencies. Like the parent is going to take the child to Brazil, and the other parent needs an emergency order to stop that from happening, because once the child is in Brazil, it becomes very difficult to get the child back. Things of that nature. It is not, as we saw in one case, about changing the formula for calculating overhead payments to Harvard and the other universities that get grants. We got an ex parte TRO on a change to the overhead formula for universities. That is madness. So of course the court is going to be getting involved more. Now we talk about the lower court defiance. Everyone, and I've said this before, so sorry if I'm being repetitive, but people talk about the president defying court orders. The president is the head of his own branch of government. There is absolutely a constitutional dialogue between the presidency and the lower courts, and maybe even the Supreme Court, about how orders are followed, what it means to have a rule of decision versus a particular order. There was a big conversation between the SG's office and the court about this last term in, which case was that? Where Sauer was saying, "Oh, of course we'll follow your rules." I can't remember. Right. It's not obscure.
Like birthright, maybe?
Yeah, it was the nationwide injunction. It was CASA. Yeah, of course. Where he was like, "Oh yeah, no, if you guys stay with the laws, we'll follow the rule. Maybe not, even if it's not in the order. Fine." Okay, you know where there is absolutely no room for a pull and push? The lower courts versus the Supreme Court. The quintessence of the rule of law. is that the things that the Supreme Court says are the law are binding on these subordinate courts. Because again, as we talked about, they don't exist in the Constitution. Their power is totally derivative of the Supreme Court. And so the notion that they have any discretion to push back on what the court is doing is completely lawless and incredibly dangerous. And they are doing it time and again. The TPS thing is a good example. We've seen this in the spending context with the Tucker Act, where the Supreme Court has said they have to go to the Court of Claims, and lower courts time and again are like, well, you didn't explain it enough. Explain it enough, you know what they're saying. They don't need to write an exegesis for you to know what you were supposed to do. Everyone knows what they're supposed to do. And so when lower courts are digging in, it is purely defiance. I really hope the Supreme Court starts to do more forward-leaning things to crack down on this, because I think it's a gigantic problem, particularly when you have the lower court defying the Supreme Court to constrain the elected president. Very, very bad, not constitutional, do not like.
Chad?
Yeah, I would just add, towards the start of this admin, there was like some commentary that the SG was, I suppose, going to lose credibility with the court in the TikTok case in particular, and that just has not proven to be true. The SG has proven to be incredibly successful at the court, so successful actually that recently Justice Jackson actually took issue in a written statement about how often the administration was winning.
Great. Well, let's pivot now. Chad, I know in your research you've written a lot about tariffs, the president's ability to impose tariffs under IEEPA. Can you tell us about the tariffs cases and give us an overview of some of the issues in those cases?
Sure. So the court is set to consider two consolidated cases concerning the president's authority to impose tariffs, and the cases concern two categories of tariffs imposed pursuant to a statute called IEEPA. The first category relates to drug trafficking, and the second category are geared towards trade imbalances and the national security risk associated with keeping domestic manufacturing humming along. In a few different places now, I've written that the IEEPA statute does empower the president to impose the challenge tariffs. And actually, there was an amicus brief filed on my behalf in this case, expanding on my scholarship there. So I thought it'd be helpful for me to maybe break down my conclusion here and explain why I do think that the president has the authority under IEEPA to impose tariffs. And I actually don't think it's a difficult legal question, despite the large political and economic stakes of the case. So IEEPA empowers the president to, quote, deal with, quote, unusual and extraordinary threats by taking a few different actions concerning imports. At one end of the spectrum, the statute gives the president the authority to investigate importation. At the other end of the spectrum, the same statute gives the president the authority to outright prohibit importation. Here, the president has used the power in the middle of investigate and prohibit, and that's the authority to regulate importation. And the government takes a position that the phrase regulate importation includes the power to impose tariffs, and the government is absolutely correct. Since the founding, tariffs have been a traditional and well-known means of regulating foreign commerce, so the ordinary reading of the statutory phrase regulate importation encompasses the traditional power to regulate importation via tariffs. Nonetheless, two lower courts ruled that IEEPA did not empower the president to impose a challenge tariff. So how could that be? Well, the analyses of both lower courts ran through a shared choke point, and that choke point was the mistaken, the erroneous conclusion that tariffs had to be an exercise of constitutional taxation power. Both courts said something along the lines of, look, IEEPA does not use the word tax. It uses the word regulate, and tax and regulate are different things, so IEEPA does not include the power to tax via tariffs. And the problem with that logic is that not all tariffs are an exercise of the taxation power. For over 250 years, tariffs have also been understood as an exercise of the power to regulate foreign commerce, and the originalist evidence on that is overwhelming. It finds support in the views of James Madison, Chief Justice Marshall, Joseph Story, and the revolutionary pamphleteers. Speaking of seventh grade, like the pamphleteers we learned and say no taxation without representation, they conceded, oh, by the way, commerce regulating tariffs, those are not taxation.
Even the pamphleteers?
Even the pamphleteers are yeah. So it also finds support in an act called the Tariff Act of 1789, which was signed into law by George Washington on the 4th of July. It doesn't get a lot more American than that. And so in some...
The sesquicentennial surprise it will be when the president signs another one.
It also finds support in a bunch of Supreme Court precedent, right? So in some, the originalist evidence, the presidential evidence is overwhelming. Like tariffs do not need to be an exercise of taxation power. They can instead be an exercise of commerce regulation power, and that's relevant because recall, the statute says the president can, quote, regulate importation. So viewing that statutory term within the context of 250 years of history, it becomes clear that the ordinary meaning of the phrase regulate importation includes the power to regulate importation through a traditional and well-familiar means, tariff. So I would therefore ask people in the audience to listen carefully to challengers to the tariffs over the next couple of weeks and see how much of the opposing argument hinges on the idea that tariffs must be a tax, right? You might hear people say, well, the founders didn't want the president to have the power to tax, or the non-delegation in the major questions doctrine applied differently to the power to tax, or the IEPA statute doesn't use the word tax. The question you should ask when you hear those arguments is, well, isn't it true that not all tariffs are taxes? Isn't it true that tariffs can be an exercise of the authority to regulate commerce? And if it is true that tariffs can be a constitutional exercise of the authority to regulate commerce, then why exactly does a statutory phrase that says regulate importation not include the authority to regulate importation through traditional means that have existed for 250 years? Now, with all that said, the commerce regulation power, it is true, of course, is vested in Congress, not the president. So for IEPA to delegate that authority over to the president, it's going to have to survive the non-delegation scrutiny and major question scrutiny. But neither of those doctrines poses any problems for the tariffs. Start with non-delegation. Existing non-delegation precedent, which has not been challenged in these cases, makes clear that the doctrine applies far less stringently, if at all, in the foreign affairs context. This case is indeed about foreign commerce, so the lax to non-existent version of the non-delegation doctrine applies. But even if we were to apply the version of the non-delegation doctrine that applies in the domestic context, this delegation would still not pose a constitutional problem because IEPA limits who can impose the tariffs, what the president can impose the tariffs on, when the president can impose the tariffs, the time length the tariffs can last without reauthorization, and the scope and the magnitude of the tariffs, which is limited by a statutory requirement that tariff authority, quote, may only be exercised to deal with an unusual and extraordinary threat, ... and may not be exercised for any other purpose. So just last term in Consumers Research, the court permitted a broad delegation of domestic taxation or commerce regulation authority, and that domestic delegation did not impose any numerical limit on the executive branch. The executive branch could raise as much money so long as it was, quote, sufficient to support a government program, and the court reasoned that those words were enough for non-delegation scrutiny. As the court reasoned, if you told a friend to order a sufficient amount of people, sufficient amount of food for 5 people, and 500 boxes of pizza showed up at your house, you would not think the friend had followed instructions. So showing that, yes, look, the statute is imposing limits on the president. Here, the same analysis would apply because, again, the statute limits the president to only using the tariffs to deal with specific threats. So to paraphrase the court, if you told a friend to get food to deal with 5 people and 500 boxes of pizza show up, you would not think the friend had followed instructions. So the non-delegation doctrine is not going to be a problem. What about the major questions doctrine? Also not going to be a problem. As Justice Kavanaugh explained last term, the court has never applied that doctrine in the foreign affairs and national security settings, and the court should not do so. There's kind of a split at the court now about what the major questions doctrine is. For those justices who see the doctrine as a substantive canon promoting the constitutional value of non-delegation, those justices should allow the doctrine to develop in a way that is just as sensitive to the foreign affairs setting as the underlying non-delegation doctrine is. And then for those justices who see the major questions doctrine as a linguistic canon, those justices should account for the fact that Congress routinely delegates major authority to the president in these settings. Finally, and moreover, the major questions doctrine is not applicable in these cases for another reason, and that's because the president has not claimed unheralded authority as the major questions doctrines use that term. Nearly 50 years ago this fall, the same statutory phrase, regulate ... importation, same phrase, was judicially recognized as granting the president tariff authority, President Nixon. So this is not a new power pulled out of an old statute. This statutory power has been judicially recognized for nearly 50 years. So in conclusion, I think this is going to be a big blockbuster case, mostly for the political and economic significance, but as a legal matter, I really just don't think it's difficult. The originalist evidence, which should carry a lot of weight at the court, is just frankly overwhelming.
Well, I'm curious because, James, you were talking about remedies earlier, and if either one of you want to weigh in, I've heard the administration talk about what does a remedy look like in this case, and what are the potential significance of a court decision ruling against the administration on the tariffs issue?
So I suppose if they rule against the administration, there's going to have to be, I suppose, trillions of dollars that's going to have to be paid out. That'll create a lot of havoc. The court should be aware of that. I suppose there could be some litigation about appropriations problems. Is there a statute that permits that? But it would be huge. Yeah.
The only thing I would add, that's a fantastic overview, is it's an interesting case because it is one of the few really important cases that has not hit the court's docket, interim docket, whatever docket we want to call it, at all. So we have no preview of what they think because the feds, the CIT and then the Fed Circuit both stayed their orders. The lower court pending the Federal Circuit pending the Supreme Court. And so it's kind of fun. I mean, normally these big cases, by the time they get there, it's like, we kind of know what's going to happen. Here, the court has not said a word.
Right. Interesting. Well, let's keep moving. James, I'll turn back to you. The court is considering a pair of cases this term involving transgender sports issues. Tell us about those.
Yeah, okay. So, everyone's been waiting for these cases. This is whether the Constitution requires men to be allowed to play women's sports. The answer is no. The Equal Protection Clause was not ratified or understood at the time of ratification to require that men play women's softball or whatever. And so I don't think maybe they didn't have softball, but whatever the sport was, this was not meant to interfere with single-sex sports. That's obvious, right? It's like almost ridiculous that we actually had to have a Supreme Court case about it, but we do because a bunch of lower courts have said the opposite. So that's like high-level stuff. Here's, I think, the more specific analysis. So everyone, I assume, is familiar with Bostock. Bostock is an opinion written by the justice I clerked for, Justice Gorsuch, for 6 justices, where the court said that Title VII prohibits firing people or taking adverse employment action against them when they're gay or transgender. Okay. I think you can fully embrace Bostock and still conclude, and I think this is what's going to happen, that the sports are fine, that we're still allowed to have girls' sports. Here's a few reasons. First of all, it is not discrimination to allocate people who are differently situated to different categories, okay? So discrimination is when you treat somebody worse because of their sex, right? So if we say that the men have palatial bathrooms here at the Heritage Foundation, they are wonderful, and the women must go to an outhouse down the street, you might say that is discrimination because that is obviously disparate. The women are being treated worse. That's not nice. That's mean, bad. If instead you said, the men are obviously biologically different and in general stronger, faster, and such than women, so they will play. Their boxing match will be over here with the men, and the women's boxing match will be over here with the women. That's not discrimination at all. It's just allocation because there is a different situation for men and women. It is a perfectly logical distinction, which is why it never would have occurred to anybody in 1865 or 1868 or 1968 or like 2008 that you would have any other paradigm. And here's the other reason. The whole point of Title IX was to allow women to play sports, because we understood then that letting men take all the sports slots discriminated against women, because men are on average, as we've just discussed, stronger, faster, whatever. I'm not trying to be mean to women. I have 2 daughters. It's just a fact that the men tend to be faster, right? The WNBA teams would not be able to compete against college men's basketball teams. They just can't because of the biological differences. So it would be quite surprising if the statute that was passed for the express purpose and general understanding of protecting women's sports somehow now meant that all the boys in this room get to go join the Harvard women's basketball team. I probably wouldn't make it because I'm only 5'7", but some of you probably would. And that is obviously crazy. So I don't think the court's going to do it. And I'm not sure exactly how they're going to do it. I'm not sure what they're going to say. They are 100% not going to overturn Bostock. Making arguments about how Bostock is wrong is a bad plan. They do not want to hear about that. Justice Gorsuch wrote Bostock. I promise he doesn't think it's wrong. So if you are involved in the case, I would not file a brief saying, oh, that was really dumb. You should do that over. Do not do that. You don't have to do that. You can embrace that decision, whether you think it's right or wrong, and still win this case. And so I'm not sure. I think they're going to say something like what I just said, which is that discrimination and allocation are actually different things, and you are allowed to allocate people when there is a legitimate, plausible, non-pretextual, I'm not sure again how they're going to phrase it, but a good reason to do it. Here's the other thing I hope they don't do. I really hope they don't say that some sort of heightened scrutiny applies. Why? Because if some sort of heightened scrutiny applies, but it's satisfied in these cases. Because then what's going to happen is we're going to have 8 gajillion lawsuits in California and Massachusetts and all these places, and the women's volleyball coach is going to be spending all of his time in depositions rather than teaching the girls how to set and spike. Because we're going to have to go sport by sport. Oh, does tennis require allocation? What about the chess team? Probably not the chess team. You probably can't do the chess team. Even I think you probably can't do the chess team. But crew, basketball, golf, what we do not want to have is a treasure hunt through every conceivable sport while some district judge in San Francisco is deciding whether whatever form of scrutiny, intermediate or whatever, is satisfied. Also, I know we're going to win. How do I know we're going to win? 2 things. First, strong indicator. In one of these cases, Little versus Hecox, the plaintiffs are running away. They are trying to dismiss the case and get it away from the court. So they obviously think that they are going to lose. Here's the other reason I know we're going to win. There was a case called South Carolina versus Doe. So South Carolina has a bathroom law. The men in the men's room, women in the women's room. Also a pretty easy issue, in my opinion, for all the same reasons. The Fourth Circuit, God bless them, had said this law is illegal, violates equal protection and various other things. I think it was just equal protection, and so therefore it's unconstitutional. South Carolina went to the court for an emergency stay to let them enforce the law. They lost, but 3 justices noted their dissent. Justice Thomas, no surprise, Justice Alito, no surprise, and Justice Gorsuch. So if Justice Gorsuch thought emergency relief was appropriate for the South Carolina bathroom law, then I would be very surprised if he has a problem with men and women's sports. He also has 2 daughters, just saying. And I think that means his vote is good to go. If we have him, then we win, because we have the Bostock minority was 3. It was Alito, Kavanaugh, and Thomas. Barrett wasn't there yet. Yep, that's right. And so we get those 3 plus Kavanaugh plus Gorsuch. I think Justice Barrett's going to be fine. And look, the chief is an eminently sensible person. The Chief Justice is definitely not going to say, I'll bet you all my Bitcoin, I actually don't own any Bitcoin, that he will not say the Title IX and equal protection requires that the boys be on the girls' basketball team. So I feel very good about this case. It's going to be great.
Dogecoin, maybe.
I do have a Dogecoin. It's like a physical Doge. I mean, you can't have that, but we're going to win, so it doesn't matter.
I'd be shocked if the cases come out any different.
Great. Well, let's pivot and go to the election context now. Chad, can you tell us about Louisiana versus Calais?
Sure. So the dispute in this case began when a group of voters sued the state of Louisiana for having only 1 congressional district of a population that was predominantly made up of black voters. And the voters bringing the lawsuit wanted a second majority-minority district in Louisiana. And a federal district court in Louisiana agreed with the challenging voters and concluded that the congressional map likely violated the Voting Rights Act or the VRA. And the theory was that the lack of a second majority-minority district resulted in unlawful vote dilution of a racial minority and thus violated the VRA. And a Fifth Circuit panel upheld that decision. So the state of Louisiana had a predicament. Although the state might have disagreed with the federal courts as to whether the Louisiana map violated that statute, the VRA, the state recognized that if the state remained out of compliance with these federal court orders, the state might be subject to a court-drawn map rather than a map drawn by the state itself. And that court-drawn map could put in jeopardy kind of key representatives that any state would want to keep in Congress, such as the Speaker of the House or the state's representative on the Appropriations Committee. So in light of those federal court rulings, the state redrew its congressional maps to create a second majority-minority district. After the state did that, a second other group of voters sued the state, this time saying, hey, well, that second majority-minority district amounted to an unconstitutional racial gerrymandering. So the state was stuck between a rock and a hard place. On the one hand, our challengers asking the state to consider race more. On the other hand, our challengers saying, no, you can't consider race more, both suing the state. The second case makes its way up to the United States Supreme Court. When arguing before the Supreme Court, the state essentially said, look, although we might have disagreed with the lower courts about whether the VRA required us to do this, the fact of the matter is we had federal court rulings essentially requiring us to do this. And the responsible thing to do for any state would be to draw the map rather than be subject to a court-drawn map. Inherent in that argument, which was argued at the Supreme Court last term, inherent in the framing of that case is the assumption that the statute, the VRA, is constitutional. After oral argument last term, the Supreme Court decided that it would hold the case over for re-argument this term, and the court ordered the parties to brief a supplemental question, which asked the following: whether the state's intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments to the Constitution. So the core of the second and upcoming argument in this case is whether the VRA can constitutionally require the creation of a second majority-minority district without violating the 14th and 15th amendments. The parties have now submitted their supplemental briefing in this case, and in supplemental briefing, Louisiana argues that the map with the second majority-minority district does violate the Constitution. Their position is essentially, look, we didn't want to create this map to begin with. We thought it would be unconstitutional, but the lower courts required us to essentially make this map, and rather than defy lower courts, we went ahead and did the responsible thing and abided. But now, justices, that you've given us a chance to speak to the underlying question about whether the VRA is constitutional, we're going to address that straight on. Now, I'll note that the state is represented by kind of like a young rising star in the conservative legal movement, Ben Aguanaga, who serves as the state SG. I think he has 3 cases at the court this term, so he's doing a tremendous job. Opposite the state are challenging groups of voters who argue in their supplemental briefing that the court's interpretations of the Reconstruction Amendments permit Congress to sometimes permit to allow for considerations of race. But in making that argument, the challengers kind of have to march through a rather Byzantine system of precedent that seems to kind of confusingly allow race considerations in some situations and not others. And that seems to require the court, and it requires the courts to go through this list of lengthy list of factors and not even exhaustive list of factors. So in making that argument, I think the challengers kind of reveal why the court might be inclined to simply wipe away some of that precedent and kind of address this constitutional issue anew straight on. And to kind of widen things up, although voting rights litigation is not my specialty, I think Louisiana has the better of the 2 arguments. I would say that given the court's call for re-argument, most folks probably predict that the court's going to hold the VRA, or at least some interpretation of the VRA, to be unconstitutional. So the tougher question is whether that ruling is going to be broad or instead be decided in Louisiana's favor on more narrow grounds. My guess is that we get a broad ruling indicating that to the extent that the VRA requires drawing congressional lines based on race, then the VRA is unconstitutional.
Great. And just to emphasize for folks here in the audience or watching at home, it's fairly unusual for the court to set a case for re-argument, isn't it?
That's right. The only one I recall is Citizens United.
Citizens United, I believe Roe versus Wade, Brown versus Board, and that typically I think it's signaled maybe a change in the court's thinking in certain issues in the past.
For sure, yeah. My understanding is that a similar issue was teed up in a similar litigation with Alabama, but that argument was deemed to be waived. So I suppose now the court's saying, well, we're calling for supplemental briefing on this to present it squarely to us. Yeah.
Right. Anything to add, James?
No, I mean, all I would say is for those of you who are lawyers, this area of the law is quite weird because it requires the state to figure out where all the black people are and then put them in a place where they can all vote together, which is really a gross and bizarre requirement for the law to impose that seems quite obviously to violate the Equal Protection Clause. I mean, everything about it is so reductionist. The idea that race is binary is obviously a very weird concept actually in our country. The idea that races are supposed to or presumed to be voting homogeneously is bizarre and thankfully increasingly incorrect in the Trump era. And so I'm not at all surprised that they want to take a look at this. It is very strange it's existed a long time. And I'm sure some of them would say, look, there was a period of time in our country where this was the necessary solution to a very serious problem, but that time is not today. And so it is time to stop bucketing voters based on, I guess, their self-identified race. I don't even know how they test that. I assume it's self-identified.
Right. Well, let's move on. Chad, there's an important free speech and religious liberty case, Childs versus Salazar, the court's going to hear. Can you tell us about that one?
Yeah, so this case concerns Colorado law, again, that has been challenged as unconstitutionally prohibiting licensed counselors from having certain conversations with their minor patients. The petitioner here, she's a counselor. She only speaks with minors, of course, with permission of the guardians, and even apparently selects these kind of teenage patients, I suppose, who are, quote, internally motivated to seek counseling as opposed to being required to come. And the challenge Colorado law prohibits engaging in, quote, efforts to change behaviors or gender expressions, or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. So because the Colorado law allows a counselor to speak in a way that promotes transitioning from one gender to the other, but prohibits the counselor from speaking in a way that promotes not transitioning, the law has been challenged on First Amendment grounds. A particular note, the petitioner is a counselor who only engages in, quote, talk therapy, right? This is her method, is called talk therapy, which just means talking, from what I can tell, or using words, speech. The counselor does not engage in kind of long abandoned practices like electric shock therapy or things like that. You might hear some commentators, as this case comes up, kind of conflate those old practices with just simply talk therapy. So it's worth repeating that the counselor here only uses words, talk. The 10th Circuit nonetheless ruled that the law does not target speech, but instead only regulates speech as an incident to regulating conduct. The idea, as I understand it, was that the law targets a type of conduct called treatment. And so by labeling the counselor's action as a conduct called treatment, the 10th Circuit is saying the state can more easily regulate that conduct. But I'm not sure that rhetorical trick works, because if you look underneath the hood, the treatment being performed is only talk therapy. It's speech, right? So the 10th Circuit's position seems hard to square with the record, and indeed a 10th Circuit dissent kind of took the majority to task on this point. I suspect one of the main doctrinal payoffs of this case will be to clarify that professional speech is still speech, and you cannot simply evade heightened scrutiny by referring to a professional speech as conduct. And it's important to determine whether a law targets speech or conduct, because if it targets conduct, then the government only typically needs to prove that the law satisfies a rational basis review, which is, for the one lawyer here, that's easier to satisfy. Perhaps sometimes you reach some sort of immediate level of review if you're regulating conduct that incidentally affects speech. But if the law is targeting speech, particularly viewpoint here, the state is saying you can take this viewpoint, you can't take that viewpoint, that's going to be subject to strict scrutiny.
Great. And I think this could have fairly wide implications because, unfortunately, many states, as I understand it, have these same types of restrictions as Colorado.
Yeah, I'm not sure about the exact state numbers, but I'll say, and I think the dissent made this point, if this is permitted under the First Amendment, you can have the precise opposite law. You can have a law that tells counselors you are not allowed to tell people that it's okay to transition. So I don't think anyone is going to be happy.
That might be okay.
I don't think anyone's going to be happy with the states taking a position on these viewpoints.
Anything to add, James?
No, I mean, Colorado's obviously going to lose. It's not close. The court's not going to say you can ban people from talking to people about however they want to talk to them about their gender process. I mean, it's 6-3.
Well, we're coming toward the end of our conversation today, but before we wrap up, I did want to ask both of you, we saw a little bit last term, and we've seen some over the summer, discussions about the dynamics among the justices themselves, particularly with Justice Jackson, maybe taking very direct shots at some of our colleagues. I think we saw Justice Barrett responding last term as well. I'm curious to know, what do you make of that?
Look, I mean, I don't think it's like, you don't have to be a court criminologist to get the sense that Justice Jackson is wearing thin on the other 8. Not just the 6 that are, kind of R6, but all of them. If you want to do the Scalia thing, you have to be Scalia, okay? You have to be good at it, right? Throwing a bunch of crazy haymakers is not a good way to win a boxing match. And I think what Justice Jackson will learn, if she cares to learn anything, is that behaving that way is only going to make her lose more boxing matches, which is fine. I mean, I'm great. Please, Justice, please share your thoughts more often. But it's going to have the opposite of the effect. So obviously, the person who's the most unhappy about this has to be Justice Kagan, because Justice Kagan is the opposite, right? She's someone who wants to get wins, not get attention. And all Justice Jackson wants to do is get attention. I would also just say, like, some of this, I mean, there's one line that is just, I really have to point out. So in Casa, she wrote this really over-the-top dissent, and that's where, Justice Barrett had some very, I thought, Scalia-esque responses in the majority opinion. I was really glad that she did that. It absolutely called for it. But the best line in Jackson's dissent was she said, "Oh, imagine a Martian from another planet came here and saw this rule." And it's like, dude, Martians are not from another planet. They are from one planet. There was only one planet from which the Martians could come. And so I do wonder if that was a justice line or a clerk line, and I have suspicions about which one it was.
Chad?
Yeah, I just mentioned, you mentioned Scalia, and I think Justice Barrett was asked about this recently on one of her interviews with her book, that Scalia took to heart the ideas, you're disagreeing with ideas, not disagreeing with people, so you can have these are adults at the height of their profession at the court. They know how to disagree with each other without, hopefully without disagreeing with the person. So I think some of the heated rhetoric, it's important to remember that they're disagreeing.
I mean, I don't know, he was pretty mean to O'Connor, but he was very funny about it. One thing I wanted to say too is, what's really weird is she's doing this a lot in these cases about constraining the executive. So her point is, you guys are pikers because you're letting the president do whatever he wants. And this is an illegitimate institution because it's letting the president do whatever he wants. Now, it doesn't really make a lot of sense if you actually play out the consequences of that reasoning. If the Supreme Court is an illegitimate institution, a bad institution, an institution that should not have any power, what is the consequence of that? The consequence of that is that the president can do whatever he wants. Because if the president doesn't have to listen to the Supreme Court, that means there's going to be more presidential power. So these sort of, what I would say are like winks and nods toward court packing and all the other jurisdiction stripping, like various ways that Congress could mess with the court. And I think that her rhetoric is infused with some of these sort of gestures in that direction, would be a calamity if your goal is to have a court that constrains the president more. Because I guarantee you that as soon as there are 18 or 25 justices or whatever, everyone here, actually it wouldn't be anybody here, as soon as the court is tripled in size, the president's gonna stop listening. Why would he listen to like the 28 people that have rotating sittings at the Supreme Court? And that is going to be a very different paradigm for the United States. And so I just think it's counterproductive in the narrow sense that it makes her lose cases a little more than she otherwise would. But it's also counterproductive in the broad sense because attacking the institution is only going to weaken the institution. And if you want the institution to do things, the last thing you should be doing is undermining its credibility with the public. I find it totally baffling. Maybe she hasn't thought it through.
Excellent. Well, I think we're unfortunately out of time for our conversation today. Please join me in thanking James and Chad for joining me for this preview. And thank you all for coming. And with that, we are dismissed. Thank you.